That was a surprise.
What were you doing? Looking for?
I was looking at papers and I suddenly thought, and then I realised, and I knew immediately where they had come from. Thank you very much.
Just stay there.
I demonstrated for my colleagues.
Oh, I see.
Yeah.
I thought you might find it a bit of a nuisance.
Right, good afternoon, my lords, my lady. We left off just as I was about to turn to Miss Daniels' statement. I know we looked at this, sorry, that's tab 25 of the report. We looked at.
Supplementary bundle.
I do beg your pardon. The supplementary bundle. We looked at this this morning, but there's just a couple of points, and I think we got the core issues out of it. There's just a couple of points I wanted to emphasise, and therefore take you to it again. So, picking it up, we're at 303, page 303 of the supplementary bundle. The first point is to look into who Ms Daniels is. Secondly, why she's making the statement. And thirdly, what she actually says. So, paragraph 1, she's the partner, solicitors for defendants, and has the conduct of the proceedings on behalf of the defendants. And paragraph 2, she's duly authorised to make the statement on behalf of the defendants. So, when one's talking about, well, maybe we'll think about withdrawing this or how valuable is this admission, one needs to take those two core facts into account. Then, why is she making the statement? We get that at paragraph 3. It's to support the defendant's position at the CCMC, where the court considered but did not conclude or make a formal order as to disclosure. So, she's making this in order to guide the court as to what the issues in the case are, thereby requiring disclosure to be made. Skipping down then to paragraph 10, she says there are 3 core issues that remain to be determined, and the second of those is a disclosure in respect to the copyright infringement claim. There's also some disclosure of breach of partnership, which is focused on the content of the video. So again, clear that this disclosure is going to the copyright infringement claim. She then refers, turning over the page, she then talks about passing off. There's one element that I'd like to just slip in, if I could here. Paragraph 12, when she's talking about the passing off claim, she does say that there are 33 clients that have been based in the UK, and only 5 of these customers purchased a subscription. So, although this is sort of parked, just want to sort of drop in the point that it is that there is a UK element there to be investigated, should it be required. She then talks at paragraph 14 about the videos, and she says there's a dispute between the parties over the video, whether the videos post 2016 are relevant to this claim. Now, as I understand it, that originally arose because it was being said that there was no, let's just use the word use, post January 2016, but that position then changed, and she explains that at paragraph 15, that in the meeting of the 23rd of March 2021, the Defendants Council confirmed the defendants accepted they made limited use of images of the risk and price charts generated by the software in presentations that were either produced after their license was revoked or were produced prior to its revocation or made available to their customers after that date. So that's the sort of license defence that seems to have been originally in the pleadings, but seems to to have gone. And she then sets out the current position. The defendants do not accept that the images are copyright works, but if they are found to be copyright works, their primary position is the author of those works is the user of the software, not Mr. Mitchell. This is set out in the amended defence paragraph 49. So we've got there a summary of the 3 non-infringement issues, the license point which seems to have gone, the no subsistence point, and the authorship point. And then she says at 16, if the defendants are wrong, and the claimants demonstrate at trial that Mr. Mitchell is in fact the author of the copyright works, the defendant will accept that this applies to the risk and price charge produced by any version of the software. Accordingly, any video that was produced after January 2016 that contained a risk or price charge originating from the OptionNet software will amount to an infringement, as will any video produced prior to that date. And then why it fits into what she's opposing. On this basis, the defendants do not see any need to disclose the 5,615 videos, as these will not assist the court on the question of liability and will greatly increase the cost, time and cost of disclosure. So in my submissions, that is, now I am going to do it this way, the clearest possible admission that the points in issue on infringement are subsistence and authorship, and that's it. The license point has gone away, but there is no other point, and that if the claimants show the first 2 of those things, effectively that is proof of infringement. And that then melds into the reservation of right point as on the pleading as taken by the other side, which I have to confess I don't fully follow, as to why in the pleadings it says, here are 2 examples, we reserve the right to rely on more. Well, of course, once this submission is made, they don't need to do that. And of course, that is on statement of truth. So that is why we say that subject to the 2 points we've discussed, infringement then follows. So those are my submissions on admission in the pleadings and my submissions on admission made in the witness statement. In my grounds of appeal, I rely on a 3rd ground, which effectively is admissions by conduct. What I was suggesting I was going to do was rely on my written submissions on the basis that I'm not convinced that if I'm not home on 1 or 2, I'm not going to get any further home on 3. So I will move on really to responding to the other side's response to this appeal. Now, they've made submissions on it wasn't admitted, and your lordships have my point on that. The secondary point they take is it's all too late. And I think that's put effectively 3 ways. The first is it should have been raised at trial, which they say proceeded on the basis that infringement was disputed in the entirety. My primary point on that is that I say it was taken at the appropriate stage, namely the consequentials hearing, the submissions that went in for the consequentials, and it would not have been necessary to actually take it to trial. It would have certainly been helpful to make it clear at trial, but it was not necessary to take it at trial. If I'm wrong on that, then I do need, I think, to reopen a point that was decided at trial. That raises additional considerations of finality. But I say in view of the fact that we raised it at the consequentials, together with the conduct that I'm going to refer to when I take you through the timeline, it is an appropriate case in which the judge could and should have reconsidered had he come to a finding. And finally, I think I want to deal sort of separately with the point now taken, which was not taken down below, that at this late stage, they're shut out of the opportunity to withdraw any admission if made. So perhaps I can start with the factual scenario. It should have been raised at trial, which allegedly proceeded on the basis that infringement was disputed in its entirety. Now, what my learned friend did this morning was take you to some of the evidence, trying to make good the submission that we knew this was coming, and in particular, or we knew or should have known this was coming, and in particular I'm talking about the targeting point. And where I'm going to on the evidence is this. My understanding is that the evidence of Mr. Mitchell was put in when the license point, let's call it that, was still live, and it went to that point. He took you through the evidence in some detail, and there is nothing in that evidence that goes to targeting whatsoever.
Well, he would have had no reason to address targeting because there was, as Mr. Loveday accepted, there was no pleaded case for targeting. Indeed.
But what Mr. Loveday seemed to be suggesting was that the evidence we put in chief, we knew that infringement at large was disputed, and we addressed our minds to addressing the entirety of that case. And what my submissions are, no, we didn't put in evidence on that point because it wasn't put in issue. Picking up then on the trial. The list of issues ultimately may be my weakest point, but when one turns to it, so it's paragraph, I'm looking at it in supplementary page 5. Now, these were not agreed list of issues. This was a list of issues that was debated, and then the judge said, I believe on day 3, these are the list of issues I'm going to work from. And at 26, he sets out, if Mr. Mitchell is the author, have they been infringed? So, and then he sets out the presentations and earnings. Now, again, it's not entirely clear what is intended to be encompassed in that issue. Whether it is in some respects historical, because these list of issues were old and were supposedly updated when the license issue fell away. What is certainly not there is this is all about targeting. This is an issue that you're going to have to prove. One then moves on to recall these issues, I think, were decided that they were the issues in the case by the judge on day 3. By that point, we had put in our opening skeleton argument. The other side, of course, had not filed a skeleton at all. But what they did do is file an opening note. And it is worth just looking at that, because there's a point I hoped to get out of it this morning when I interrupted, but I didn't. And so if I could ask you to turn to that opening note, which I currently can't find, tab 7, and it's at paragraph 12 of the opening note. And this is the defendants now, not us. And the point they make, so it's tab 7, page 126 of the supplementary bundle. They say the defendants are content with the list of issues with 2 qualifications, 12.1. It should not, of course, be taken as superseding the pleaded cases. Well, it's that's not really what they told you this morning. They told you this morning it did supersede. My strong submission is that if an admission has been made, either in the pleadings or elsewhere, and that admission, of course, is on statement of truth, it is not superseded by the list of issues.
Well, then you can also rely upon what's said in paragraph 1, namely the open note doesn't repeat their case as set out in their pleadings and evidence.
I could rely on that. I think but hope we had that point this morning. Yeah. Secondly, I think it is, let's just skim the skeletons. I have to accept that the level of detail in our opening skeleton was clearly not of enough assistance to the judge. But nevertheless, our skeleton argument is at tab 6. This is, of course, an opening skeleton and needs to be addressed further. But if I can just take you to the copyright issues, so that's page 122 of the supplemental bundle. We merely refer to the pleadings. 72, the position on copyrights is set out in the particulars of claim and defence and counterclaim. The software was created by Mr Mitchell. He's the author and owner. Then we say at C, images generated intellectual creation. What we don't say there, which would have been useful, but in my submission not obligatory, is if we show X and Y, then infringement is effectively admitted, or follows really, because infringement isn't admitted, this is the basis of defence. During the trial, let's move on now, there was of course neither side have identified any evidence to the targeting issue at trial. Neither side have identified any cross-examination on targeting at the trial. And that is consistent with the judgment. And if I can take you then on the judgment to paragraph 200.
Just before we get to the judgment, the point is made against you that when we look at the closing submissions, and bearing in mind we know this was sequential and there were no oral submissions, that in the claimant's closing submissions, we can see at tab 8, pages 161 to 162, essentially it repeats the opening skeleton. And so what you can say is that it all proceeds on the basis that the only issues are subsistence and authorship, and therefore ownership. And it proceeds on the assumption that if the claimants succeed on those two issues, infringement follows. But then we get the closing submissions coming back from the defendants, in which, for the very first time, paragraph 171 at page 204, the point is taken on targeting.
Yeah.
And one might have expected the claimant's closing submissions in reply to say, paragraph 171 must be ignored. Number 1, not pleaded. Number 2, they've admitted it. Number 3, this is an ambush. But instead, it's completely silent.
Yes.
So what do you say to that?
I was hoping you weren't going to ask that question, but I suspected you would. Again, there's a couple of issues on this case I cannot get around. Your Lordship is entirely right. We would have had the afternoon off had any of those 3 points been made in the closing submissions. All those points are valid, and all I can say, and I think all my learned predecessor said, is this was an oversight for which he can only apologise, but nonetheless, it goes really to the form of the order rather than the judgment. he takes these points. He takes 2 of the 3 points, and I'm going to say why the third is implicitly taken anyway, when there's argument over the form of the order. But it would have assisted were these to be taken on the closing. Your Lordship has already made the point on our closing submissions that we do flag up at the beginning that there's a whole host of new points that are being taken, and these are reply submissions. I also do factor in, if we need to be talking about reopening, the timescale. That comes from my chronology. There were 6 days here to produce this. That means it must have been over a weekend. So one's only looking at 3 or 4 working days on what, in reply submissions, ought to have been a short document. Weren't quite so many new points not being taken. So I have to accept Lord Justice Arnold's point that these points could have been taken earlier, and it would have been helpful if they were taken earlier. I make the point against that it was understandable, but I do make the overall point that if the true factual scenario was that it wasn't an issue, because it wasn't pleaded, or it was effectively accepted, then this is a matter for the consequentials, not the judgment. And then it was raised at the appropriate time. Does that vaguely go to answering the question?
It's certainly an answer.
An answer. Just stepping back to there being no evidence on the point, I think your Lordships have that point. But just for your note, the judgment power 229 notes there wasn't evidence on the targeting issue, which effectively, if it was for us to prove, meant we would have lost the issue. Now, I do accept that it can be argued that how far should a judgment go in listing the consequential relief that should be granted? Did the judge, we say in our submission, slightly overstep in that whilst it was open to him to decide that the 2 pleaded issues did not establish infringement, it was not argued before him that if you didn't get home just on the 2 pleaded issues, that there was no infringement and no relief ought to be granted. We say that point was appropriately taken at the consequential stage, and at that stage, the pleading point was taken, it was admitted in the pleadings, and the Alice Daniels admission point was taken.
So I think we need to see that, because I don't think Mr Loveday showed us that.
All right. That is tab 20 of the tab 20 in the supplemental one, and that's the claimant's submissions on the form of order. I think, having said that, something I want to take you to first. Can I just have a moment? Yes. Can I take you first of all to the email from Mr. Ethan Turner to the judge of the 5th of May, which is page 256 of the supplemental bundle. And he says this, dear Judge, I write to update you in relation to the draft order. And towards the bottom of the page, says it's now apparent there is a misunderstanding as between the claimants and defendants what matters were and were not before the court on the liability part of the trial.
I beg your pardon, I haven't found where you're reading
I
from.
beg your pardon. Page 256 of the supplemental bundle.
Right, thank you.
And what's happened is there's been an exchange of draft orders, and Mr. Eaton Turner is just updating the judges to where we are on this. So we're on the 5th of May at this stage, and he explains it's the last sort of full paragraph. It's now apparent there's a misunderstanding between claimants and defendants what matters were and were not before the court on liability part of the trial. Claimant's draft contains on the first page of the cycle that the defendants in June 2021 admitted the claimants demonstrated Mr. Mitchell, as opposed to the defendants or someone who used the software, was the author of the risk and price charts that they had infringed copyright. Start again. Was the author of the risk and price charts they had infringed copyright? Then he refers to the statement of Alice Daniels, and on the following page he says that admission was never withdrawn, and this position was reflected in paragraph 51A of the amended defence. And then he cites the amended defence. What I get from that is effectively that both the point on the pleadings, the admission on the pleadings, and the admission in the witness statement were matters that were drawn to the attention of the first instance judge. These are not matters I'm raising newly on appeal. On the perhaps third point, that targeting wasn't pleaded, I'm not sure that's even a point I've taken in my grounds of appeal, but really it is the other side of the coin to the admission made in the particulars, in the defence.
Well, you did take the point because you relied on CPR 16.5.
Well,
and you made, as you said this morning, you rely upon the point that applies you to plead any positive cases.
yes.
The positive cases pleaded were no subsistence, you weren't the author. No positive case pleaded on targeting, on the contrary, wasn't it?
Yes. What I'm saying is I take the point, but I don't quite put it that way that targeting wasn't pleaded. What I say is that what was pleaded is if you prove X and Y, then Z follows.
Yeah, well, the two go
And
together.
it's the two go together. Your Lordship has my point. There were longer submissions made on the form of order, which I can take you to. They effectively take me no further than what is said in that email, but they appear for reference, and I can take you through them if you require, if I can find them. And it's in my note. 20. Tab 20 of the supplemental bundle, which is supplemental bundle page 275, and there's a number of that, and there's further submissions made on the admission point at page 284.
And the key point that's made is paragraph 16, live issues on the liability trial since June 2021 have been whether copyright was capable of assisting works, and if so, the author is.
Yes.
Yeah.
Yes. That leads me then to, am I at the stage where I need to apply effectively to reopen? My primary case is that this is not effectively an application to reopen. The point was run, or the points were run, at an appropriate time, at the consequentials, because it went to the consequences of what the judge decided and not the factual findings themselves. I'm not asking your Lordship, your lordships to overturn the judge's finding on the two pleaded incidents, but I am saying that he jumped the gun somewhat by deciding in his judgment on the consequences of that. If I'm wrong on that, to the extent that it is a reopening, it's a very minor one, if I can put it that way, because I'm trying to reopen consequences, not factual findings. The Supreme Court has set out a sort of multifactorial analysis as to circumstances in which it would be appropriate. As I understand it, I think I have 4 points that are put against me. The main point put against me is that raising it at this late stage shuts out their opportunity to withdraw any admission if made. Well, to some extent, I say this. Firstly, as we've just discussed, actually this is two sides of the same coin between can they run targeting and can they withdraw the admission. If one thinks of it the other way, with the other side of the coin, can they now put in an amended pleading in which they plead targeting? Is effectively what they're saying. The basis upon which they withdraw the admission is, can we at trial, closing, amend our pleadings to add targeting when there's been no evidence on this issue and the trial's just completed? And we say any judge would have had very little difficulty in saying you're far, far, far too late. Secondly, this point, I now rely on this, was not raised by the defendants before the trial judge. We raised our points, admittedly on the form of the order, and when we did, there was never any contrary point saying a reason you shouldn't look at it is that we might want to withdraw our admission. Thirdly, the point put is that, thirdly, there is no basis floated at all from the other side as to the basis upon which they might withdraw that admission. They've just said they're deprived of the opportunity, but they've raised no basis on which they might actually do that.
Am I right in thinking that under the CPR, if you want to withdraw an admission, you have to file evidence? Isn't there a rule that says if you want to withdraw an admission, you have to make an application supported by evidence?
I suspect so. I think my learned friend deals with the relevant part of the he may have put the relevant part of the CPR in the authorities. Part 14. Rule 14.5, it's in the authorities bundle, tab 11. That sets out the basis upon which it would be decided. Doesn't go into detail as to whether you actually need evidence.
Is there anything in the practice direction?
There may well be. practice direction 14.7. That's
So I assume that what we're looking at page 334 in the authorities bundle is the current version
I'm not.
of part 14. We seem to have an older version at 346 where it's 14.15, but again, it doesn't answer my question.
And unfortunately, neither does the practice direction for paragraph 7.
No, as I read the practice direction, it does not require evidence, but it would seem to me that a large number of the factors that go to the facts and matters on which the court would have regard would require evidence. That's the best answer I can give you at this stage.
Thank you.
My lord, just to sum up then, if there are circumstances, now I think the final point I'd like to just respond to is this point that this is all rather archaeological, and it was all made quite a long time ago. With respect, I submit that's an extremely bad point. It seems to say that if you've got a case that takes 3 years to get to trial and you admit something in your defence on day one, then it becomes archaeological and you can't then rely upon it. If something's in a pleading, it doesn't really matter when it, ultimately when you get to trial, when it came in. If your lordships decide that this is effectively an application to reopen, and need to put into the pot whether it is in the interest of justice in order to reopen. I say the 5 key points on whether it should be reopened are probably the following. The point on which the defendants won, let's put it that way, was targeting. This was a point that was, 1, not pleaded, 2, not in the list of issues, 3, not raised in opening because, contrary to the CPR, no skeleton was filed, 4, there was no evidence on the point and no opportunity for us to put evidence on the point. Because of 5, it was only raised at the last possible moment, in I think the anti-penultimate paragraph of their written closing. We say if one needs to consider discretion, those factors overwhelmingly would circumscribe an instance in which the discretion for the minor reopening to consider the relief, not the factual finding, should be granted. So, my lords, I've taken up.
Can I just ask you
5
about
minutes.
the
Yes.
judge's reasons as given in his email of the 12th of May, which is right at the back of the supplementary bundle? He there sets out, as I understand it, why he thinks it's too late, as you put it, saying that, in particular in the middle, nowhere, it wasn't anywhere put in correspondence agreed that all issues of infringement should be tried later, and he goes on. So what's your response to what he set out in that?
If I could pick it up on the last part of his ruling, and he says,
Pardon, could you give me the page again?
I do beg your pardon,
Free to
it's in
read.
the supplemental bundle, that's page 328.
Right at the back.
Yeah, right at the back. And he says the following, just below the bottom hole punch. I was therefore asked to rule on only 2 claims of alleged copyright infringement, as identified in issue 26. Leave the list of issues one side. He was only asked to rule on 2 claims of alleged copyright infringement, correct. The order on the judgment reflects my findings on those infringement claims. We say that was in error because his ruling on those 2 claims was correct. Where the error came was the consequences as to that ruling.
Well, I don't understand how you can say it's correct in circumstances where it's your submission that the issue was never raised and there was no evidence. I mean, it's implicit in that it's not correct because it's being decided in a way that is procedurally unfair. And that means it's not correct. I mean, it's only correct in the sense that in the absence of the issue being raised and no evidence being directed to it, it's correct.
I think your Lordship put it far better than I did, and I perhaps admitted, took on too broad, too much of a concession. He is correct on the basis of the evidence before him.
Yes, the absence
of evidence. He came to the right decision in the absence of being told. But my understanding is that whilst the pleadings, I think your Lordship put it better than I did, and maybe I needed to be more robust in my criticism of the judge in answer to Lord Justice Moylan's question. I'm sorry, I'm being whispered out from behind me.
Yep.
Yeah, but there's an answer to the point as put, but actually Lord Justice Arnold's answer is better. The answer to the point as put is that when one looks at the original first draft order, it was limited to a finding on those 2 issues and those 2 issues alone. And I could put it like that. And the way we've been putting the case is, well, it may well be on those 2 issues there was no evidence before you. There wasn't. But nonetheless, I would like to adopt the way Lord Justice Arnold puts it in that it's better, is that even that decision on those 2 instances was procedurally unfair in that the issues that they were lost upon, i.e. timing, was not pleaded. So I do go further than perhaps where I put my submission 5 minutes ago, that finding, firstly, that finding on those 2 instances is procedurally unfair. But even if it stands, the consequences of that finding does not lead to the generality of a finding of non-infringement throughout.
The previous part deals with, and it starts with the correspondence. It nowhere in correspondence would it said that all issues of alleged infringement post January 16, and he refers to issue 27. So he saying that was an issue that was before.
I think that he's misunderstood. The learned judge has misunderstood what's being put to him. It is not being put to him that whether or not there are issues of infringement should be decided at the inquiry. He seems to have misunstood the situation, in that what's being put to him is, we know we lost on those 2, but we reserve the right to argue targeting in respect of others at the inquiry. That was not what was being requested, but that's what he perhaps seems to have been suggesting what was being requested. We are not for a moment saying that any issues of liability
Thank you very much. Yes, Mr. Loveday.
Two short points. The first is about withdrawal of admissions. My learned friend said that if my clients had applied to withdraw such admissions as may have been made, that would have been post-trial, it would have been in closing, and it would inevitably have failed. I have two responses to that. The first is on the merits of a withdrawal application. Now, that application, if it was made, could have had all kinds of evidence in it, and this court simply does not know what analysis and what details from the procedural history would have gone into an application of this kind. As I've mentioned earlier, this court's only really in a position to skim the surface by looking at the materials that the judge was shown on the post-judgment submissions. But we don't know what materials might have been put into a withdrawal application in terms of explaining why the admission was made, whether the context had changed and so on, and whether there was now an appropriate time to allow, in fairness, to allow that admission to be withdrawn, prejudice to both sides and so on. So I don't accept that the merits would not have got us there. The second is responses regarding the timing of a withdrawal application. From my client's perspective, as far as we can tell, the claimants didn't, in 12 plus months in the run-up to trial, say they were relying on an admission point. And my lady and my lords have my points on that, on the conduct in that period. But if the claimants had squarely said at any point in the run-up to trial, please remove this from the list of issues, we want to rely on an admission, then that could have been an earlier chance. Or indeed they put it in their particulars of claim, we rely on an admission. That could have been an earlier chance for a withdrawal application to be made. And the court, the learned trial judge in May of this year, and indeed the court now, is not in a position to say that would have failed, and we were deprived of the chance to put forward our best case on such a withdrawal application. My second reply point is about the point about targeting not being pleaded, and I entirely take my Lord Justice Arnold's point that in some ways this is the other side of the coin with CPR 16.5. But I do wish to emphasise this wasn't one of my learned friend's grounds of appeal. It wasn't spelled out in his skeleton argument for this appeal, and indeed it wasn't raised below. My response to it is a very short one, which is pleading points of this kind must be raised at trial. They must be raised at the earliest opportunity, as early as reasonably possible. And if pleading points of that kind are not raised in this way, then the relevant party waives the right to raise them. They had every opportunity to object if there was any procedural unfairness to them, and they didn't do so. Unless I can assist the court further, those are my submissions.
No, thank you very much indeed. Sorry, excuse me. Thank you very much to you both for your respective submissions and for the assistance given, no doubt, by those behind you. We will reserve our judgments. They're provided to you in draft in the usual way for typographical errors, and you will know from the case whose name I can never remember the very limited purposes for which you can make use of our drafts before hand down. And we would hope that once you've received the drafts, you will be able to agree and order, but if not, we'll deal with any outstanding matters on written submissions. So thank you very much again.